The Transfer of Property Act 1882 is a mess. That's the reason the property cases goes on in pendency for eternity in Indian courts. Suggestion: the legislature should make land immovable property identified by Google geographical location longitude and latitude and unique identification number like PAN card number. So all the litigation to title transfer to mortgage details available to all. Notes by Praveen on Lease Pendants. C. 52 of the Transfer of Property Act says the doctrine of lease pendants. Lease means litigation and pendants means pending. So, lease pendants would mean pending litigation. The doctrine of lease pendants is expressed in the well-known maxim pendent lit innovatur, which means during pendency of litigation, nothing new should be introduced. During pendency of any suit regarding title of a property, any new interest in respect of that property should not be created. The doctrine of lease pendants prohibits the transfer of property pending litigation. The Indian court have also taken the view that basis of Section 52 is not the doctrine of notice but expediency, i.e., the necessity for final adjudication and public policy. It has been held in Govinda Pillai v.S. Ayyappan Krishnan, AIR 1957 that the foundation for the doctrine of lease pendants does not rest upon notice, actual or constructive, it rests solely upon necessity. Property is transferred or otherwise dealt with during pendency of suit. The property must be transferred or otherwise dealt with by any of the parties to suit. Transfer includes sale, exchange, lease and mortgage. The expression otherwise dealt with has been interpreted to mean those transactions in which although there is transfer of some interest in the property, a contract of sale has been regarded as a transfer within the meaning of otherwise dealt with. Therefore, entering into contract of sale of the disputed property during litigation shall attract the provision of this section. 6. Involuntary transfers. Involuntary transfers. Transfer of property may either be by act of parties or by operation of law. Transfers by operation of law are known as involuntary transfers, e.g., court sale or transfer made by order of court. Section 52 is applicable to both the kinds of transfers pendent light and in Giridra Nath Sinha v.S. Krishna Kumar Nag AIR, 1967, SC. 1440. The Supreme Court has also held that it is true that Section 52 strictly speaking does not apply to involuntary alienations such as court sales, but it is well established that the principle of lease pendants applies to such transfers. Therefore, the doctrine of lease pendants applies where the sale is made by order of the court. 7. Transfer with permission of the court. When a transfer is made during pendency of suit with the permission of court, the principle of lease pendants is not applicable. 8. Transfer by any party to suit. Transfer made during pendency of suit is not enough to attract the provisions of this. It is necessary that transfer of disputed property is made by any party to suit. In the case, Maqbool Alam Khan vs. MST. Giridra, AIR, 1966, SC. 1194, where a party to suit whose name is struck off as a contesting party by consent is not bound by the decree because lease pendants shall not apply to him. 9. Transfer affects the rights of any other party. The transfer during pendency must affect the rights of any other party to suit. The principle of lease pendant is intended to safeguard the parties to litigation against transfers by their opponents. It means any other party between whom and the party who transfers there is an issue for decision which might be prejudiced by alienation.